Senator Lankford.
Thank you, Mr. Chairman. Good morning. Good to be able to see you again and get a chance to visit with you. We've talked about before, I chair the Regulatory Affairs Committee here in the Senate, which deals with how we actually promulgate rules and regulations and the process of that. There's a separate issue with whether each reg is a good idea or a bad idea, but there is a clear legal standard for how we do regulations. You also know I have serious issues with the Department of Education, how they've promulgated some of the guidance documents, which you call Dear Colleague letters. They appear to be policy documents, and they appear to be regulations more than they are just clarifications in the process. This process started long before you got there, so this is not about you and the months that you have been there at this point, but my concern is it seems to continue at this point. So let me just highlight a couple things that I've shared with the Department of Education that you know well on this. In 2010 and 2011, there were Dear Colleague letters that were put out dealing with the Office of Civil Rights, which, by the way, has a terrific mission and very supportive of the mission that they have. The issue is the process of how it's actually coming out. One of the Dear Colleague letters interpreting Title IX forecloses all standards of proof used in disciplinary proceedings except for preponderance of evidence. Now, in our conversation, and from the letter that I received back from my letter, the statement was there were two letters of findings from Georgetown and from Evergreen State that were the basis for that. So here's my question. Do letters of finding form a legal precedent? Do other people have to be able to follow a letter of finding from a different university? Is that a legal precedent?
No, as we talked about, we don't view those findings as setting precedent.
So let me ask you this. So another school shouldn't have to rely on compliance to a different school's letter of finding?
That's right. And
same with the guidance documents, they're non-binding as well. Is that correct?
That's right. The institutions are accountable to the law and regulations. The guidance is intended to provide clarity and examples of best practice.
So let me just follow through on that, because this becomes the struggle as I deal with the universities around the country. So if schools were to ignore the letters of findings and the guidance documents, which are all non-binding, rely on their own good faith interpretation of the Title IX language, this equitable resolution, if they were to rely on their own good judgment on that, their own legal counsel on that, then are they okay on that? If they rely, instead of preponderance of the evidence, if they rely on clear and convincing evidence, are they okay? They're within their bounds to do that.
So as we discussed, our interpretation of equitable resolution is that requires the preponderance of evidence standard, and our goal with the guidance is to convey our interpretation of the law. But an institution has the opportunity to go to a hearing, or beyond that, to go to court to challenge a potential finding from the department.
So what I'm trying to determine here is if there was a letter of finding that you say this is the precedent for it, that they can't use clear and convincing evidence, they now have to use preponderance of evidence, and they have to shift to that, why that isn't a regulatory decision that's made. Because if I look at the phrase from the law that says equitable resolution, I'm not going to immediately look at that and say that's preponderance of the evidence. You're saying it's not legally binding. You don't have to go by a letter of finding. They don't have to go by guidance. But if they don't, we're going to take them to a hearing and to court.
So we believe, based on the department's longstanding, and this is, as we discussed, this is a longstanding interpretation of equitable resolution that predates this administration. Longstanding interpretation that equitable resolution would mean preponderance of the evidence. That is certainly the civil standard as well.
It didn't at Yale. It didn't at Harvard. It didn't at Princeton. It didn't at UVA. It didn't at Ohio State. And I could keep going through a lot of universities that all use clear and convincing evidence that now had to shift to a new form of that because of a guidance document, a Dear Colleague letter that came out to them that they felt compelled to be able to shift from one to the other. So you can say it's longstanding. It was longstanding in some institutions. It was clearly not longstanding in all of them. I'm not getting at whether that's the right or wrong evidence, which, by the way, I think preponderance of evidence is not a high enough standard. But that's irrelevant. The issue is this came out from a Dear Colleague letter, not from regulation. There wasn't an open conversation on this. It didn't go through the process. There was a new interpretation of equitable resolution that outside entities didn't have the opportunity to be able to participate in, which is the law. So what I'm pushing is when the Department of Education promulgates a new rule, promulgate a rule. Go through the legal process. Don't send out a Dear Colleague letter and say we had a letter of finding from two other schools And so that's the basis now for a dear colleague, which would create a new guidance, which universities have to shift all their policies, add a tremendous number of staff, change all their procedures on something that wasn't a regulation.
Senator, I appreciate, as I indicated, I appreciate the concern. I think our view is that in cases that came to the department prior to this administration, prior to the guidance, the standard that we applied was our interpretation of equitable resolution as preponderance of the evidence. But appreciate the distinction you are making, and I think we are happy to work with you and your staff to look at, are there ways that we can more clearly communicate to higher ed institutions?
Which I'd be glad to do.
Yep.
Ken Talbert, who's the lawyer, used to be the general counsel of the Department of Education. When he saw the letter that came back from your office, used the phrase, glossed over the question whether the department is obligated to use a formal rulemaking process. We're saying two different things. I'm saying there's a formal rulemaking process. You're saying we had some prior stuff, we have the grounds to do it. This is a legal question more than it is anything else. I do want to continue this. I'm looking forward to your response to the next letter on this. But when a formal counsel from the Department of Education says, I'm being glossed over, I think I'm being glossed over in this. And I want us to be able to resolve this, the process of how we actually put out guidance. And I'm way over time. I apologize, Mr. Chairman.